Members of the jury, our system in the trial of civil actions is to divide the questions that arise in a lawsuit into two classes. One class of questions we call the questions of law, and the other class of questions we call the questions of fact. The questions of law comprise rulings upon objections concerning the admissibility of evidence, the potential trial in general, and the determination of motions made during the close of the case. These questions of law, which include advice to the jury as to the law of the case, are all for the judge to pass upon, and the jury is bound to take the court's ruling on such questions. On the other questions, which we call the questions of fact, the law says a jury of 12 men must pass, and they are supreme in determining such questions of fact. This system of conducting trials does not ask for a judge's idea as to who is telling the truth, but asks for the jury's finding. Therefore, you are required under the law to decide this case upon your conscientious conclusion as to what the proof requires you to find in respect to the questions involved. Questions of fact concern these disputes between the parties as to who is telling the truth. Issues of fact, they are sometimes called. One side contends that a certain thing happened on a certain occasion. The other side contends that another thing happened. The difference between them is an issue or a question of fact, and it is the jury's duty to decide those questions. You remember that when you were sworn as jurors, you were sworn to decide this case according to the evidence, and that expression in your oath exemplifies what your duty is here, which is to decide it as the evidence requires you to decide it, and not as you might choose to decide it as a matter of sympathy, or as you might decide it if prejudice should exist in your minds. You are to lay aside all questions of sympathy or prejudice and determine what the facts and the evidence in this case require you to say is the truth. The most important thing in the conduct of litigation is that the truth should prevail, not that one man shall get another man's money or that the other man should keep his money. Those things are not nearly so important as is the proposition that the truth should prevail in a court of justice. With that admonition as to your duties, let us see what the questions of fact are which you must decide upon the evidence. In this case, the plaintiff claims the right to receive from the defendant a certain sum for brokerage commissions. The plaintiff is a licensed real estate broker, and the defendant corporation at a certain time was the owner of certain real estate. The law says that if the owner of real estate hires a broker for the purpose of procuring a customer for the property and given terms of employment, and the broker pursuant to that hiring goes out and procures a person who is ready, willing, and able to buy upon the terms of the hiring, that then the broker is entitled to and has earned his commission. The plaintiff seeks to recover on the theory that he was hired to sell this property upon certain terms and at a certain price, and that he procured a customer who was ready, able, and willing to buy that property at that price, and that he advised the seller that he had such a customer. If he has established those facts, he has earned his commission and he is entitled to recover. If he has failed with respect to any particular to establish those facts, he is not entitled to recover anything. From that brief statement of the law in a case of this kind, let us see what issues of fact have arisen. I said that the law is that a broker who is hired to sell real estate or to procure a customer to buy real estate must establish that he has secured a customer ready, able, and willing to buy upon the terms and conditions of the hiring. So you can see from the statement of the law there are two things necessary. First, the making of the contract of hiring, that is to say that the broker was hired to go and sell the property, and second, the performance of the contract by the broker. Therefore, this plaintiff has the burden of establishing to you, first, that he was hired as a broker to sell his property.